Please be seated. Good afternoon, everyone. We have two cases set for oral submission today. The first case I'm going to call is Chavez versus the State of Texas, number AP 77,117. We will hear first from counsel for the appellant, I believe Ms. Posel. Ms. Posel, you have 16 minutes for your opening. You've reserved 4 for rebuttal. Is that correct? Okay, please proceed at your leisure.
Good afternoon, Your Honors, and may it please the Court. Thea Posel on behalf of Appellant FACUNDO Chavez. This is an appeal from a conviction and sentence of death out of El Paso County. Today, I'd like to spend our time together discussing the points of error 1 through 3 concerning the deprivation of appellant's peremptory strikes, and time permitting, the trial court's error in failing to discharge the jury after it indicated that it had reached a deadlock on special issue number 2. The peremptory strike has been a feature of jury trials dating back to English common law and has always been held essential to the fairness of the trial by jury. While nothing in the text of the Constitution guarantees the right to peremptory challenges, the Supreme Court has referred to them as one of the most important of the rights afforded to the accused. In Texas, Article 3515 of the Code of Criminal Procedure guarantees capital defendants in a case in which the state is seeking the death penalty 15 peremptory challenges. And Article 3513 dictates the order in which jurors shall be passed, first to the state and then to the defendant. In this case, the trial court deviated from the mandatory procedures for capital cases, instead employing a procedure more appropriate for non-capital cases, in which the parties were ordered to submit their strikes by email. By doing so, the trial court deprived appellant of his full peremptory challenges to which he was entitled by law.
When did the appellant object in the trial court?
Your Honor, there was no objection in the trial court, but that does not forfeit the error here because the error was not apparent to any of the parties. And in fact, to appellate counsel until we received the sealed clerk's record in May of 2025, almost 2 years after trial. At the point in which the trial court received the strikes, in volume 70 of the record, she reads into the record the jurors who were selected, not the strikes of the parties. So trial counsel had no notice nor cause to object and cannot be held to forfeit that error.
Wait, so they're emailed more or less simultaneously, right?
That's correct, Your Honor.
So, I mean, wouldn't the fact that you know that that's the procedure, wouldn't that lead you to presume that, well, if the court opens this email first and this email second, I mean, you kind of know what's going on there, so how would you address that concern?
Well, not exactly. I think it's theoretically possible that the trial court could have accepted strikes by email and still complied with the mandatory order of 3513 by first examining, as it went down the list of qualified jurors, whether the state had exercised a peremptory challenge against that
But
juror.
how do we know that didn't happen?
Well,
In other words, if the court took the state's challenges, knocked them out, and then took the defendants and knocked them out, how would we know that the result would be any different than what we have here?
Well, Your Honor, because 3513 requires that they be passed first to the state and then to the defendant, and the law in Texas is clear that capital defendants do not have to exercise a peremptory strike until the state exercises theirs. So if the state had struck the juror that was double struck in this case, then she would no longer have been in the pool for defense counsel to strike. And further, in volume 70, where the jurors—
But what I'm asking is, assume that happened. How do we know that applying all of the defendant's strikes would have not taken strikes out of the area that the ultimate jurors were selected in? How do we know we're out of the strike zone? I'm trying to understand how we know that there was any difference at all. First, I don't know that we know how the court actually applied these email strikes. And second, assuming for the sake of argument that they were applied contemporaneously, how do we know that it made any difference?
Well, thank you for that question, Your Honor. One of the reasons why we know that the parties did not know that this occurred is because the trial court did inform the parties that they had double struck on an alternate juror, but did not inform them that the double strike occurred in the selection of the petty jury.
Was there an objection to the double strike on the alternate jury?
There was not, because the sequence of the alternate jurors that was proposed had 1, 2, and 3. The parties double struck on potential alternate 3, so both had accepted the first alternate. And even had the trial court decided to apply the strikes.
Doesn't that say the strikes are out of the zone of the jurors that were ultimately selected?
Sure, so 48 jurors were qualified for the strike zone.
But if they struck an alternate, doesn't that conclusively establish that the strikes were going outside the zone of the jurors who were accepted?
No, Your Honor. In fact, the trial court selected and read to the parties the names of the jurors who were within the strike zone for the Pettit jury, and then read separate names from which the alternates would be struck. And had the trial court, as you say, chosen to do this contemporaneously, that still would have been error, because Texas law allots to a capital defendant the right to exercise 15 peremptory challenges after the state. Case after case in this court's jurisprudence has observed that this right is one that is benefit
Let me
of the
rephrase it a
defendant.
different way.
Sure.
Can you point to a juror who ended up on the panel who would have been struck had the defendant been afforded an extra strike?
Yes, Your Honor. I believe we don't know for certain, as you point out, but 2 jurors who were seated after the double strike occurred had both been challenged for cause by the defense. And so one of those jurors, ultimately juror number 9, was challenged on the basis of her pro-law enforcement views, her connections to the El Paso County Sheriff's Department, and other views that she expressed during voir dire. So it is highly likely that had the defense counsel been informed that they did not actually need to expend a peremptory strike on the juror that was double struck, they may have selected either juror 5, who was also challenged for cause by the defense, or juror 9, and then ultimately juror number 12 in this case would have been the last remaining juror in the panel that was qualified for the Pettit jury, and that was juror 10 from panel 4.
Did they ask for any additional peremptory strikes?
Your Honor, they did not. And so what that would do is fail to preserve any error for the denial of the cause challenge, but that doesn't impact the court's analysis here. So when this court is considering a violation of a statute that pertains to the formation of the jury, this court has said that the traditional 44.2b error assessment is not quite appropriate. Instead, because the court said formulations that focus on the outcome of the case are not quite apt in the context where the jury itself is the object of the error. Instead, reviewing courts look to the purpose of the statute, what right was protected by the statute that was violated, and whether the statute's purpose was thwarted by the error that occurred. Here, both the purpose and the rights protected by 3513 and 3515 were violated. Appellant did not receive the advantage allotted to him by law to exercise the strikes after the state, nor did he receive the full 15 peremptory challenges to which he was entitled by law.
But wouldn't he have known at the time that he was making his strikes that he didn't know who the state was striking? And so he knew that he was running the risk of doing a double strike before it ever happened.
That may have been a risk, Your Honor, but the fact that that occurred was not apparent, and it could have been conducted in compliance with the mandatory order had the trial court elected to proceed that way.
But isn't the purpose of requiring a contemporaneous objection to give the trial judge the opportunity to avoid the error in the first place?
It is, Your Honor, but again, where the defendant was not on notice that it had actually occurred, that they cannot be held to have forfeited that error.
But he was on notice that this procedure was carrying that risk. If he wanted to object to that procedure, did he have an opportunity to say, I don't want to exercise my strikes blindly, I want to know who the state has struck before I exercise mine?
Well, had the only error that occurred been an improper sequencing, I think Your Honor's point would be well taken, but what happened here was that the failure of the trial court to follow the procedure and the error in turn created the error of depriving appellant of his full 15 peremptory challenges.
To follow the law, if, as you posit it, your client would have known at the time he was exercising his peremptory strikes that he did not know who the state had already stricken, right? Which would be true every time the statute's complied with, right?
I apologize, Your Honor. Every time the statute is properly complied with in capital
If
cases?
this, as you position the statute, the state is to exercise its peremptory strikes first to avoid the problem that you're presenting to us here today. In this case, the defendant knew that he didn't have the list of the state's peremptory strikes before he exercised his own, right?
That's true, but he did not know that the trial court was not going to accept the strikes in the process that is required by law.
I'm having a problem with the math here, so help me with it, okay? You got a jury of 48, you got a panel of 48, right? 15 strikes on each side.
Yes, Your Honor.
Okay. So if they come back and 30 jurors are struck, both sides know, hey, all 15 strikes went in. If they come back and 29 jurors are struck, then we know, there's a double strike. And if it isn't 29 because the balance of the strikes end up outside the zone where 12 are selected, then we know those strikes didn't make any difference at all. So either the defendant knew there was a double strike, in which case he could have stood up and objected, or some of those strikes were completely moot, in which case it moots his argument that lacking that extra strike made a difference. And I'm trying to figure out the math here. Is that not the case?
I don't believe so, Your Honor.
Why not?
Because in part, because the trial court read not the strikes into the record, but the selected jurors. So appellant was not in a position, trial counsel was not in a position to count the strikes as they were read and determine whether one had actually been expended unnecessarily. And that is the language that this court uses for statutory violations. They say, and you...
Okay, but we presume the defense used its strikes in the order that they found the jury's objection.
Correct.
And if the jurors came back and 30 strikes hadn't been used, then either there was a double strike, or some of those strikes that the defendant used ended up outside the remaining 12 people who were used, in which case having more strikes wouldn't have made any difference at all. The only way we get to the possibility that losing a strike might have made a difference is if we extrapolate that the defense might have changed its mind after being informed that it had one more strike and hit somebody earlier in the zone. And I don't know how we can make that assumption.
Well, Your Honor, respectfully, I believe it's precisely because that assumption is impossible to achieve that this court has said that such errors where the defendants are deprived of their full allotment of peremptory challenges are reversible error. And I think that the math is certainly not my forte, but looking at the list of jurors here, the law is clear and provides that strategic advantage to which you refer to the defendant. In case after case, this court has referred to it that way.
But if that strategic advantage under the facts of this case couldn't in any way have conferred a benefit, how is there harm?
Well, it would have conferred a benefit, Your Honor, because the selection or deselection, really, when we're talking about a panel of qualified jurors, is made in relation to the relative desirability of the jurors in relation to those that remain on the panel. So once the state struck this juror, the defense would have retained that same number of jurors and examined an entirely different panel, and then been able to determine, do we still want to accept the jurors as it's constituted?
When you say examined an entirely different panel, you don't mean to imply that they would have broken the panel and got a new one?
No, certainly not, Your Honor, but the composition of the panel would be much different, and the deselection strategy calls would have been different for that reason.
So in a perfect world, the judge would read the state's list of 15 and then kind of look at the defense and say, okay, I just listed their 15. Do you want to take 5 minutes to make sure that you still want to stick with yours? Is that like if you were advising a district judge in a perfect world to comply with the statute, is that kind of how it would go?
Well, in a perfect world, Your Honor, the strikes would be exercised in open court in sequence as they are in every other case where the qualified panel procedure has been used. If the judge instead was for some reason insistent on importing this inapplicable statutory procedure into this case, she could have avoided error by doing what Your Honor just proposed.
Can you tell me at what point in time, can you hear me?
Yes,
Sorry. At what point in time did the trial court inform the parties that there had been a double strike on the alternate juror?
After the trial court had read into the record the names of the 12 jurors that had been selected.
Okay.
So it was reasonable, I think, for trial counsel to assume that had a double strike occurred during the selection of the petit jury, the trial court would have informed them of that as well. While this is not statutory construction, this is a similar canon that we have because there is no discernible reason for the trial court to have informed the parties about the double strike in the selection of the alternates and not in the selection of the petit
So
jury.
is your argument that somehow the trial judge, by informing the parties of the one double strike in the alternate zone and not informing also at the same time about the double strike that was not in the alternate zone, somehow misled the defense counsel? So the defense counsel then, even though they might have otherwise said something at that time, so that they didn't have that opportunity because they were misled into believing that there were no other double strikes?
I personally wouldn't have used the word misled, Your Honor, but I think the factual circumstances make it reasonable for trial counsel to assume that they would have also been informed had that occurred during the selection of the petit jury. And so considering whether they forfeited complaint of this double strike during the selection of the petit jury, they had no way nor notice to know.
Is it error for to allow defense counsel, I mean, it might be a bad idea, but is it error for defense counsel to strike someone that the state also wants to strike as a peremptory strike? I mean, is that something that, it seems to me that it might be that some defense counsel might do that, right? And it might be a useless act, right? But that doesn't necessarily mean that they didn't have some reason for making sure that it was known that they didn't want that juror.
Well, I struggle to imagine what that reason might be,
Me
Your
too,
Honor.
by the way.
It's okay to say no.
I do think that part of the reason, I've never seen this type of error before. I have found no case in which this occurred. And I think part of the reason is that the law is clear about the procedures in each type of case. So
Counsel,
had that
your
occurred.
time is running down here. You have, in addition to your jury charge, or jury selection argument, you've got a couple of points on the jury being deadlocked, or you assert that they're deadlocked.
I do. Thank you, Your Honor. Judge Erie, I will attempt to answer your question on return.
I'll try to re-ask it better.
Okay. Just regarding the jury's deliberations and deadlock on special issue number 2, it is true that this court has said that there is no fixed amount of time that is appropriate or inappropriate for jury deliberations. But several aspects of what occurred here distinguish this case from those in which the court has found no abuse of discretion on behalf of the trial court. For one, the state cites cases such as Howard versus State, Green versus State, and Andrade versus State. But none of those cases did the jury send a second note indicating that they were still deadlocked following the submission of a supplemental charge like occurred here. Furthermore, unlike the deadlocks that were reported in Howard, the jury here was hung on the same special issue for both deadlocks. Special issue number 2 is different than special issue number 1 and the question of conviction, right? This is not a factual determination in which the state carries the burden. This is a context in which jurors are asked specifically to exercise their individual moral judgment and determine whether sufficient mitigating
How many total notes came out? Was it 3 or 4? Because if I remember correctly, there were a couple of yes and a couple of no and a bunch in the middle. Then it was a few more in the middle and moved to the yes. How many notes total were there?
Well, Your Honor, this was a very communicative jury. So in total, they sent 7 notes. But the first several notes occurred in the context of their deliberations on special issue 1. So first, they requested some evidence. Then they reported to the trial court that they had taken several votes that were both 6-6. Then they reported to the trial court that they had taken another vote, and it was 9-3 on the first special issue. And it was at that point that the party started discussing whether a supplemental charge would be appropriate. The next day, they told the trial court in the morning that they had reached a verdict on special issue number 1. They moved to deliberate on special issue number 2. And after several hours of deliberation, they reported to the trial court that they were deadlocked, that they were 9 votes for no on the second special issue, 1 vote undecided, and 2 were very firm for yes. It was at that point that the supplemental charge was issued, in which jurors were instructed to continue to deliberate, but do not violate your conscience, and do not surrender your honest belief to the evidence. And they were also instructed to ask for additional guidance had they more questions at that point. Now, in other cases that this court has considered, juries have done that, and this court has looked to the requests for guidance or requests for additional evidence after submitting their note of deadlock to show that jurors were continuing to deliberate. But that is not the case here. So after they were informed of that, they did not ask for additional guidance and instead reported their 2 yes votes were again very firm.
Counsel, I know your time is up, but I do want to ask a question. If Howard sets the limit, and this court ruled in Howard the judge did not abuse his discretion, and in this case, the conduct appears to be well within Howard, can we grant the relief you're seeking without overruling Howard?
Yes, Your Honor. If you're speaking about the time frame in which jurors were deliberating, in Howard, it was a longer stage of deliberations, but it was a much longer and much more complex case. So the opinion in Howard notes 19 days of testimony, and in this case, the merits phase of trial was 6 days, and the penalty phase was just 2.
So the dispositive issue in your mind, why Howard wouldn't be dispositive here, is because of the amount of testimony and the length of trial?
Certainly not, Your Honor. This is a fact-specific inquiry with several factors to be considered, including the length of deliberations, but also the specific language of the jury's notes and whether any other notes were sent requesting evidence or other instruction following the report of deadlock. So I see my time is up. I will return on rebuttal.
Thank you. You have a few minutes for rebuttal. We will now hear from Ms. Estrada Quinn.
Good afternoon. May it please the court, opposing counsel. My name is Rebecca Estrada Quinn. I'm here on behalf of the El Paso District Attorney's Office, and we represent the state in this matter. I'd like to just begin by addressing the first three issues that appellant designated, and then if time permits, I'll address the other two that they wanted to address also. Just to begin, the trial court did not take any arbitrary or unauthorized action here. It understood what 3513 stated. It understood what that entails, that it entails the order of the strikes being made as the individuals are, veneer members are verdired. When the parties approach the trial court and say, we want to change this because we want to be able to see the entire panel, qualified panel.
Can I just interrupt you? Because
yes, sir.
I guess I'm led to believe at this point, and maybe I'm just wrong about it.
Yes, sir.
You described it as the parties approached in order to tell the judge what they wanted, but it was really the state who was saying, this is what we want.
No, well, yes, Your Honor, the state was more vocal, but the defense was in agreement. There was never a time where the defense
Well,
says they don't
what did the
want
defense
to
say
do this.
that makes you think that we can read into what they said, saying that they agreed? What words did they use to express agreement with what the state wanted to do?
There may not have been words, Your Honor, but I believe in the three discussions, there's three separate ones, because of this one, I believe the prosecutor tells the trial court that it believes that the defense is in agreement. The defense doesn't say they aren't. And so I believe I set that out in the brief. I don't represent that they specifically are also talking. It's the prosecutor who is talking about the
I'll just tell you why my
procedure.
flags are up about it. It's because in the state's brief, what I read is an argument that the defense, what's the word I'm looking for? They asked for it, right? That they were in, it reads as if the state's argument is to say, they can't complain about this because they asked for it to happen this way.
Well, our
But it was really
position-
the state
Yes, sir.
that was asking for it to happen that way. It's from my read, and the defense seems to have not said anything about it, which is what leads, I think, ultimately to some of our question about whether or not it was preserved. You see what I'm saying? There's a difference between saying they asked for this too versus they didn't complain about it early enough so that the judge could fix it.
Well, our position is that we don't know exactly what the parties discussed in terms of what the prosecutor was more vocal, but the defense attorney, the defense team was very experienced here. They don't disagree that this is how they want to select the jury. And that's why we believe it's an agreement. The trial court is informed about this. And the trial court does let them know, well, there is this 3513, and the procedure is supposed to be different. And the next time that the parties do discuss the matter, it does appear that the trial court has gone ahead and allowed for this to be the procedure. Now, the appellant argues, well, that the defense didn't have time to object to the fact that the trial court then, once they have the panel, tells the parties, there's a discussion about this is how you're going to submit the strikes, you're going to get the jurors' strike sheets. And what she's essentially informing the parties of is the non-capital case procedure. They're going to make their strikes, and those strike sheets are in the sealed court record. And yes, the parties made their strikes on the sheets. She's letting the parties know, she's giving them a week to do this. They're discussing how the logistics of it. I believe the defense wants an extra day to meet so their client can be involved in the
Let me just interrupt you there for a second, because
process.
normally in a capital case, as
Yes,
you
sir.
go through the procedure, whether the state's required to make that strike before or after the defense inquires of an our person, the defense team knows which juror is going to be struck.
Yes, sir.
And here, that did not take place.
It did not.
And, I mean, I guess there could have been a way where they would have been provided the state's strike list, but that didn't happen either.
That didn't happen.
What motive would the defense have for even agreeing to something like that? Because it put them in the position of double striking.
It's hard to know. I don't know the strategy involved. I can discern that they wanted to not make a premature strike, that by going through that process that 3513 sets out, they didn't want to, they preferred to be able to see the entire
Was this a
panel.
judge, was this a judge's idea or the state's idea to do this? Because it sounds to me like the defense, to some extent, has been kind of quiet throughout all of this.
They were quiet, but these were experienced counsel. They understood, they had tried cases before. They never disagree that this isn't how they want to do it. They weren't forced into this. They've tried, I believe they state that both of the two lead, there's three counsel on the team, and the lead and the next counsel
I'm just
have
curious
tried
because it
these
clearly
cases
deviates
before.
from 3513.
I'm sorry?
It clearly deviates from 3513 and how the strike should take place.
Yes, sir. No, I believe that too. But they're listening to the court as the court's saying, you're going to submit your strikes this way. And the trial court is describing the non-capital case procedure. But at that point is when they should have objected, not when they find out there's a double strike. But at that time, they should have said, wait, Your Honor, objection.
Is there some language in our earlier Hughes opinion to suggest that if the judge is going to depart from the sequential strike list, that it must give the defendant the opportunity to exercise additional strikes if there is a duplicative strike?
Yes, Your Honor, but our position is that they did have this agreement and that the defense understood as part of being able, as part of following, what we believe is that the actions of all of the parties shows that they were following the non-capital case procedure. That's
I understand,
what it
but
shows.
if it's the judge's job
Yes, sir.
to afford additional strikes, if the judge is departing from the 3513 sequence,
Yes.
why wouldn't the defendant rightly assume that there's been no double strikes unless they've been afforded an additional strike?
Well, we don't know what it is the defense team
Were they
did
given an
at that
additional
point.
strike when the double strike, when defense counsel was advised that there was a double strike in the alternates? Was he given an additional strike by the trial judge?
No, Your Honor.
Did he ask for an additional strike?
He did not ask for one, and so the end result was just that first, there was three jurors, 39, 42, and 45. They double struck 45. So then the court lets them know that, so that they know that that's why the first juror, 39, is going to be the alternate. And so that's how that occurred. But they didn't request a double strike on, an extra peremptory on that one.
What is your position on whether or not the defense knew, or maybe should have known, that they did not get the benefit of the full 15 peremptory strikes?
Well, our position, first of all, that there's the argument's been made that they didn't know, that they, but we don't know what it is they knew. We don't know whether whether it mattered. We don't know if part of the agreement that they, see, a lot of it is the discussions that were had as to how the procedure that was being embarked upon. So we don't know if it wasn't a concern because they didn't need an extra, in their discussions, they didn't say, wow, if we had just that one extra peremptory strike, well, hey, when we go in there, when we do the way the judge has done the jury selection, there's a possibility of a double strike. So it would have been incumbent upon them to go in there and check.
That's assuming the Hughes doesn't put the job to the judge directly, right?
Yes, sir, because, and what we would say is the judge deviated, and we believe it's because of this agreement. And when she's announcing these things and giving the instructions, this is experienced counsel who's, and so
We
she's
don't really
never
calculate
told.
whether
She's
counsel.
never allowed, I'm sorry.
We don't really calculate whether counsel was experienced, in putting air quotes around that, whether counsel was really tremendous counsel in deciding whether or not they invited error or not. I mean, the whole, you keep bringing up that, oh, these were such experienced counsel, they're very smart people.
Well-
That doesn't really, I don't know how to look at a cold record and know that. We look at a cold record on appeal. So we're only looking at, we don't see, it doesn't say in the record, these were experienced counsel. It doesn't say that.
I believe there's, and I wish I had the record, the site, but I believe defense counsel, when he's, this had been, I think, Mr. Chavez's second attorney, I believe, and he does let the trial court know that he's been in other death penalty litigation. That's why I
So,
refer
but
that.
it
it's
doesn't
not
make
his-
us presume
well,
that somehow, you know, because he's silent, he must agree with it.
Well, but I guess the way we're arguing is he has been involved in these cases, so he does understand the procedure. And so that's the only reason I say it. I
Is
understand
this
that I can't.
procedure one that was utilized in other capital cases as well?
I know that there's at least 2 others, and he was involved in, I don't have the site offhand, but the defendant is Fidencio Valdez, and the same procedure was invoked there. And then I don't think he was involved in Irving Davis, but that also was an issue. It was another death penalty litigation where the complaint was made in the writ stage, though, that trial counsel was ineffective for, essentially, it's the same procedure, the blind strikes, and I believe there have been a double strike there as well. So it appears to be, all those cases are out of El Paso, so.
Do you have an
Yes, sir.
opinion now? I mean, I guess now that we're wrestling with this question, do you have an
Yes, sir.
opinion about the wisdom of deviating from the procedure called for in the Code of Criminal Procedure?
Well, I believe that the trial court here understood and agreed to deviate because it understood this was the party's agreement. The thing that possibly should have been done is more details. The trial court, as far as we see the record, is acting as if they're following the non-capital case procedure. And she's never informed, the trial court's never, there's no objection, so she doesn't have a chance to go, oh, I didn't understand that this wasn't the agreement. She understood 3513. We have that on the record, so it's not like she doesn't know. As far as the wisdom, maybe obviously more details, but also, it's also on, the defense to say, no, this isn't what we agreed to, or yes, I wanted to see the entire requisite panel, but I also thought that we were gonna do our strikes this way, so let's either do them in court, in person, one, the state and then the defense, or I'd like to see the jury sheet strike that the defense does first before I submit my strikes. Certainly those are possibilities, but our position is nowhere on the record is the trial court informed so that it can make the decision. And so,
I think that's what the defense is saying
should she have just
too.
said no? I guess that's what you're
The
asking
defense
me.
is also saying, hey, we didn't realize this was happening to us. So it's the same
Well,
argument
but-
you're making for the trial court, the defense attorney is making for the defense team. She's saying, well, they didn't know. They
Well,
weren't
but
getting
there's no
their-
objection, and that's how we customarily let the trial court
Right,
know that we have a
that-
problem, and
That's
that's.
true, and
and
that's a
our-
big question that
Yes, sir.
I think you can tell many of us have, so.
No, I understand, and we believe that based on, although it wasn't explicitly set out how the strikes would be done when she is, when
But
the trial
didn't
court is.
the legislature set it out?
I'm sorry, sir?
Didn't the legislature set it out?
Yes, but then there's case law that does say that it's not rigid, it's subject to procedural default.
Like the
And
Hughes
so
case, but the Hughes case.
she allowed-
If the
I-
Hughes case says if the judge is going to depart from it, he's got to provide extra strikes.
Right.
If the judge doesn't tell him there's been a double strike, does there need to be objection to something that the council isn't aware of?
Well, and our position is if they agreed and they understood that this was, that by going this way, that was a possibility, that's what they agreed to.
Well, if the judge is going to risk error, sometimes smart lawyers object. Even smarter lawyers sometimes shut up.
Yes, sir.
And let the judge dig their own hole, right?
And counsel, it sounds like to me that you're arguing, or you believe that since the defense attorneys didn't say anything, then they're acquiescing in something that's going to harm them greatly. And they've just acquiesced or waived. That's what it's, you haven't used those words, but it sounded like that's what you were saying.
Well, by their silence, they're indicating their agreement with the procedure that was being set out. And then when the trial court is informing the parties, this is how the strikes will be made. Our position is, at that point, if that wasn't their understanding, or if they wanted 3513 to apply, they needed, the trial court didn't understand that. They've asked the trial court to take this deviation, but yet when the trial court is acting, they don't, if it wasn't what they intended, that's when it should have been corrected. Not after the fact when the double strike occurred. We don't believe that.
Why did the trial court inform the parties that there had been a double strike on a alternate juror? Why did the trial court do that?
I imagine so that they would know that's why the first juror was going to be the alternate, is all I can discern without knowing why. I don't know why the judge did what she did, but that's all I could determine, is that she said there's been a double strike on, there were three, 39, 42, and 45. They double struck 45.
Right.
And I think she's letting them know so that they know we're gonna have to go with 39, because she went in order. That's all I can discern from that, sir.
Would it be your position that that should have alerted the defense team that there could have been other double strikes as well? Or is the fact that the trial judge didn't say anything about any other double strikes something that could have misled defense counsel into thinking that there must not have been any other double strikes?
I don't know that it was misled. I believe that once they knew that this was the procedure that the trial court had established, that in a non-capital case, the double strikes are a possibility. And so if it was a concern, if they felt in their discussions that they would benefit from another one, then that was the time. There was still time. I mean, trial wasn't going to start that day. There was still, and they had a whole week after the trial court sends them off so they can do their strikes. They had a whole week to say, wait a minute, what just happened, you know? And so, you know, I believe that during that time, they probably could have still asked for some sort of hearing with the court.
Had the jury already been sworn at that point?
I'm sorry?
Had the jury already been
No,
sworn?
sir. I think at that point, the trial court had directed the bailiff to contact the individuals who were selected, so that hadn't happened.
So the jury hadn't been come back and taken the oath, so
No,
that
no,
jeopardy had not attached at
No,
that point.
no, sir.
So they could have started over, is you're
I
saying.
believe so, and they also had a week to make their strike, so there was time for them to recognize if in fact this was not the agreement, this was not what they had agreed to. They did have that time. And so, are there any other questions on this issue? I'll just briefly address the point of error 13 and 14. As we argued in the trial court, we relied heavily on Howard. We believe it did fall within the parameters. We disagree with the characterization that it didn't appear that the jury was still deliberating. I believe there were two notes. The first note had to do with Special Issue 1, and there were two notes, and the jury deliberated for about 2 hours. They came back the next day and were able to decide Special Issue 1. So this is in the course of a day. By about 11 o'clock, they send out a note that they're deadlocked, and I believe the count was 9-1, undecided. At that point, that's when the trial court gives the Allen-type charge, and then about 2 hours later is when they come back with another note saying that they're 10-2. So I believe from that, the trial court could see that deliberations were progressing. At this time, she's starting to talk with the attorneys. And within a few minutes, the foreperson asks if the jury can take a break so they can take a walk. And I think from all that, the trial court could infer that they were continuing to want to clear their head and possibly keep discussing. And we do feel it falls within the parameters of Howard. I believe in that case it was 7 hours.
What was the jury instructed with respect to unanimity in this case?
I'm sorry, sir?
Unanimity. In a death case, are the jurors instructed how many votes are needed for a yes to any of the special issues?
Or all of them, sir.
Right,
Yes.
but it's 12, right?
Yes, sir.
And for no, how many are they instructed are needed? Is it
I
10?
can't right off the top of my
Okay,
head
isn't
say.
it kind of telling in this case, we ended up with a lot of twos? With the jurors broken up, I mean,
Right.
there is a concern we've addressed in other cases about the effect of those unanimity instructions and the risk that jurors are told there are only two answers available, if I understand correctly, yes and no.
Yes, sir.
And if you can't get to 10, you can't answer no, right? Now, you've got the additional admonishment to the jurors, don't give up on your conscience, but there's the reality that we don't know what's going on in deliberations, right?
Correct, yes.
Right, and there's a potential pressure there, which I just find curious. In this case, we keep getting to 10-2 before somebody breaks and says, okay, potentially, I'm outvoted. I can't get to no. You see the concern there?
No, sir. I mean,
But we ended up on questions 1 and 2 in that same sequence of, we've got two.
Well, I believe it began 6-6 on Special Issue 1, and then it went to,
9-3 or,
correct,
Yeah,
and then
and
the
then
next
the
day they
second
were
one,
able
we
to
end up-
decide.
Yeah.
And just to summarize, though, we do believe that from what was happening, the trial court could determine that the jury was continuing to deliberate. And so it falls within the parameters of the cases, not only Howard, but I believe there's Green and Trevino that we've cited in our brief, and that it wasn't coercive. Counsel talked about this case not being as long as Howard and not having as many witnesses, but it was still the same issue, the same magnitude that the decision of magnitude that the jury had to decide. So we do feel that it falls, that the trial court didn't abuse its discretion by allowing the jury to continue in this case. Yes.
Thank you, counsel. Now your rebuttal.
Thank you, Your Honors. With regards to points of error 1 through 3, the state points to several portions of the record where the state proffers the idea of qualifying the panel, and the defense does not object at that point. But that is the procedure to which the parties agreed. And that is one of the two statutorily contemplated processes, as this court said in Hughes versus State.
Can I just interrupt you before you go, leave those, because I want to stick on those three for just a minute. In particular, I wanted to know what your thoughts are about what 3513 is the statute that you're invoking, right? And is it your view that that statute guarantees a particular procedure to be used, or that it guarantees that the defense gets to have 15 strikes?
Well, Your Honor, I think the 15 strikes comes from 3513, which
Right.
subsection A, which applies to capital cases. 3513 guarantees, under this court's reading of the statute, the process by which the jurors are passed first to the state and then to the defendant.
So since it is, it's a process, right? It's a procedure that is utilized in the trial court. And I think your argument is that the defense team might not have known that they didn't get their full 15 strikes, right? And yet, we're focused for some reason on the deviation from the procedure guaranteed by 3513. And I wonder whether, it's one thing to say we couldn't have objected to the fact that we didn't get our 15th strike because we didn't know we didn't get our 15th strike, but the defense did know that they were getting a different procedure than what 3513 called for. So I'm dealing with this problem of, at some point, should the defense be expected to object because the procedure that's being used is something that deviates from 3513, versus should they have had to object because they didn't get their 15 strikes?
I think I understand
Okay.
the question, Your Honor. And this court has referred to two possible ways to comply with 3513 that deviate from the strict text. the legislature in 1965 amended the Code of Criminal Procedure to abolish the unnecessary distinctions between capital and non-capital jury selection, retaining specifically that benefit to capital defendants. So in either of the, either strike as you go, as we call it, or the qualified panel, the sequence of the striking remains the same, and that's why both methods have been held permissible by this court. So I think it was reasonable for trial counsel to assume that once the panel had been qualified, the procedure or the order of the strikes would have then been followed.
If defense counsel had been informed of the double strike and not asked for another, would you say the same error applies?
If they had been informed of the double strike, I believe what should then have followed would be that they would have gotten that strike to use as they saw fit, because they technically wasted it or they unnecessarily exercised it.
But they would have known there was a double strike if they had the list of jurors, they had the numbers of the jurors, and they knew that no juror beyond 30 or whatever it was in the mix, correct? And they would have known that right away. Is that not correct? Or was the alternate selection different?
The alternate selection was different, Your Honor. There were specific jurors that were designated by the trial
No,
court.
they
for
were
each
juror 41 and 40, which once there was a double strike got back down to juror 39, right?
So what happened in this case is the court qualified 4 different panels and numbered them all starting at 1. So there were repeated
The
numbers.
final panel was 48 jurors who had been qualified.
Yes,
And those jurors are the ones upon whom the peremptory were applied.
yes,
And we started with 48.
yes.
Now, if we apply 30 strikes and 12 people, that gets us to 42. But we didn't get to 42, we only got to 41 and 40, which was back down to 40 and 39. So they knew right off the get-go that there had been a double strike.
Well, actually not quite, Your Honor. So the trial court told the parties, here's the panel from which you will select the petit jury, here are the 3 jurors from which you will select the first alternate, and here are the 3 jurors from which you will select the second alternate. So she divided them up so that the petit jury was struck from a panel of 42, if that makes sense. I see my time is up, if I may briefly conclude.
Please.
So, Your Honors, Appellant was convicted of capital murder by this jury and ultimately sentenced to death. But had the jury been properly selected, he would have been tried by a differently constituted jury. And that matters in this case where 2 jurors firmly determined, both before and after the supplemental instruction was issued, that the answer to special issue number 2 should have been yes. The fact that the trial court knew of the division, although she did not solicit it, and the fact that the instruction was issued after defense counsel objected and said, the only thing left to do at this point is for the majority to overwhelm the minority. And so the potential for coercion was even heightened in this case. Instead of discharging the jury and sentencing him to life without parole as 37071 requires, the trial court instead issued a supplemental instruction, forced the jury to continue to deliberate, and failed to accept the second reported deadlock. Ultimately, the reasoned moral judgment of those 2 jurors was overcome. For these reasons and others set forth in our brief, Appellant's death sentence and conviction cannot stand. Thank you for your time today.
Thank you very much. We appreciate the argument of counsel and the briefs as well. We will take this case under submission. With that, I'm going to call our next case. Everyone's okay? Yes? Garcia versus State. We will hear from Mr. Bennett for the appellant for 15 minutes, followed by 5 minutes of rebuttal. Counsel for the second case, feel free to approach. Mr. Bennett, at your pleasure, sir.
Thank you. May it please the court, good afternoon. My name's Mark Bennett, and on behalf of the Institute for Advanced Criminal Law Studies, I represent Roberto Garcia. The state's best argument in this case is that when Officer Investigator Womack testified, he was asked, are these 2 people in the marriage license the same as the 2 people you identified previously? And he said yes. That's their best argument, and it doesn't win. It doesn't win because the testimony was not about identification of the people in the complaint. The question here is whether the state has proven beyond a reasonable doubt to a rational juror that the people in the marriage license were the same people as in the complaint.
But didn't they also have a fingerprint match?
The fingerprint match was to the complaint. The fingerprint match matched Roberto Garcia to the complaint. And then the question was, can they match Roberto Garcia in the complaint to Roberto Garcia in the marriage license?
But that's not the, you're concerned about matching up the victim, right?
I'm concerned about both.
Okay.
Both. There was no evidence of either. Investigator Womack looked at the marriage license. He said it looks like a marriage license. In the record, this is Reporter's Record 4 at 82, I believe. He says it looks like a marriage license. He's asked some questions about it. Whose names are on there? Roberto Garcia and Olivia Lopez. The prosecutor moves on to another document, onto the complaint. Whose names are on there? Roberto Garcia and Olivia Garcia. Prosecutor moves back to State's Exhibit 30 and says, now returning to State's Exhibit 30, the marriage license, are those the two people you identified previously? The officer says yes. The two people he identified previously are the two names on the marriage license. When 2 minutes, in a span of 2 minutes, he's asked twice about the names on the marriage license. The first time he reads out the names, and then the second time he's asked, are these the people who you identified? Well, the only identification of two people that he gave was the names from the marriage license. He actually identified Mr. Garcia as the defendant in the complaint. He didn't identify anybody as the complainant in the complaint, just by name, Olivia Garcia. And unless the court has more questions, I'll sit down.
How many Olivia Garcias do you think we have in Texas?
I think there are a bunch of Olivia Garcias in Texas. I know, and it's in my brief, that there are something like 14 Roberto Garcias in Texas prison. The state says, well, only 3 of those are from Bexar County or the surrounding counties. Well, that's a pretty large number of people with a particular
From the
name.
original conviction was entered in the record.
The judgment from the original conviction.
Does
is
that
in the
judgment not have a thumbprint on it?
It was, the conviction was connected to my client, to Roberto
Okay.
Garcia.
So there's no question that this conviction was your client?
Exactly. The
Okay, so
question.
there's no dispute as to the client identity, only the victim identity?
No, well, so the question is whether the defendant and the complainant in the judgment were family members. And the way that the state attempted to prove that they were members of the same family, because the enhancement requires that.
This assault occurred 6 days after the marriage between the defendant and this purported victim.
But no, between A. Roberto Garcia and Olivia Lopez. There's no evidence that the Roberto Garcia in the marriage license is the same as my client.
So was the only evidence that they were married or had a family relationship was the marriage license?
The only evidence that there was a family relationship between the defendant and the complainant in the complaint, which I think is State's Exhibit 29, is the marriage license. That's what the state had to rely on. And that's their argument, is that, look, Roberto Garcia and Olivia Lopez got married, and then 6 days later, Roberto Garcia assaulted Olivia Garcia.
Viewed in the light most favorable to this verdict, how is it not a reasonable inference for the jury to make that these are the same people? How is this an impermissible speculation?
Because they're very common names, and we're in Bexar County, and you can't, so the inference would have to run this way. To make that inference, the inference would have to run this way. This guy assaulted this Olivia Garcia. There is a Roberto Garcia who married an Olivia Lopez 6 days previously. You would have to infer from that judgment that the two people getting married 6 days before in the same county were the same people. I think it's a guess. I don't think that that is what anybody would call a reasonable inference. I don't really know how to argue against it other than, that don't feel right, Judge. I don't know.
Does the marriage certificate have fingerprints on it or any other identifiers like birth dates, social security numbers?
I don't believe so. There was, I don't think that's come up in the briefing, and my recollection of the record of trial is no.
Don't tell my wife, but I don't remember all the details from our marriage.
You were there.
Yeah.
At least he remembers that.
But do we have some case law? I think you cited us to about pen packets. I mean, just the documents plus a name.
So that's the Beck case. The Beck case is that just the name on the document is not enough to prove that that a person with the same name is the person on the document. That is, Joe Schmo on the
What's good,
pen
what's not
packet.
good for pen packets is not good for marriage licenses. Is that your argument, basically?
No, my argument is, right, what's not good for pen packets is not good for marriage licenses, and there's no reason that it should be. It has to be proven beyond a reasonable doubt.
The marriage license was offered into evidence.
Yes,
The jury would be able to look at it during their deliberation.
correct.
The judgment was offered into evidence.
Yes.
Okay, well, I'll represent to you, at least in modern times, marriage licenses do have the birthdays. So if we're looking at this evidence in the light most favorable to the jury's verdict, why are we not able to conclude the jury looked at the marriage license, saw the birthday in the name, looked at the judgment, saw the birthday in the name, put two and two together and said, there you go.
And Judge Finley, if you look at the marriage license in this case, which is in the record, and it has the birth date of Roberto Garcia.
Is that dispositive?
It makes it a whole lot worse for us.
It does, doesn't
I hadn't considered it. I don't believe it to be the case. And I think that the state would probably have argued that if they, in their briefing, if that had been the case. And I think the Court of Appeals would have written about that.
You'd think?
I would think so.
I didn't see it in the license. I actually looked at that in preparing for today, but don't quote me on that. But I wondered if there was not an application, that would have been filled out, but I didn't see that that was submitted to the jury, an application for the license that would have likely had the information, even though the license did not. But on another note, to me, the real question is when the prosecutor asked, are these the two people, basically? Isn't it possible that that could be interpreted differently than the way you're presenting it, that a jury could have seen that differently?
I rationally, no. I think it's conceivable. I think that an irrational jury could look at that and say, oh, he's saying that these are the same as the two people as in the complaint. But looking at the context, first he says on page 82, this looks like a marriage license. He's clearly not familiar with the document. He says the two names. And then 4 pages later, he's asked this question. My question is this. If that officer knew that the people in the marriage license were the same as the people in the complaint, why did the prosecutor not say, are these the same two people as in the complaint? Didn't, because that wouldn't have been the truth. We had an officer who was telling the truth. Started out by saying this document appears to be this thing, wasn't asserting anything that he didn't know, got to ask the question, are these the people you identified earlier? Where the only two people he had identified earlier together were the defendant, the one person he had identified was Thumbprint, was the defendant. The only two people he had identified together were the two names on the marriage license.
Counsel, I'll clarify. I have the marriage license here. It does not have the birth date. It has the address, but not the birth date.
Okay. And I don't think that that address is elsewhere in the record.
I don't find it to be.
Okay. So I accidentally was correct.
There you go.
It happens.
Indeed you
Well,
were.
the question is, I follow what you're saying, but I know in trying cases, sometimes I would say, are these the people, you, as the prosecutor or a defense attorney, are these the people, maybe, do you think it's possible that the prosecutor could have been saying, are these the people, meaning, the people in court that day?
I think the only two people identified, well, I don't think that the complainant from the original case was in court. Otherwise, she could have been called to testify and testify that when I was the complainant in this prior case, we were married, if that were the truth. So I think that would have wired around this whole thing. But the question, so I'm thinking of it as defense trial counsel. I'm sitting there and this question is asked, are these the same two people you've identified? If I think that that question is, are these the same two people in the complaint, I'm on my feet and I'm objecting. I know we're going to get a question here about this, but I'm objecting that there's a lack of personal knowledge, because I know the officer doesn't have personal knowledge. Instead, there's this ambiguous question asked, and while I think that an irrational juror might reach that conclusion that, oh, this means that these are the same two people as in the complaint, I don't think that a rational juror could rationally conclude that.
Can I shift you to do you think that it's possible that the appellant invited error during the motion in limine hearing when the state was putting on evidence, asking questions about the dating relationship, establishing that, that there was a relationship, and then both lawyers, I think there were two attorneys that say, Judge, we don't need to do this. In fact, one said, in other words, Judge, they have what they need to prove the priors without the appellant's admissions. Is that not inviting error?
It's not. Was this in the
motion in
bail
limine.
hearing or in the motion in
The
limine?
I'm sorry, it was in they filed a motion in limine, and I believe that was in the statements were made during the bond reduction hearing. And then they filed a motion in limine, and then the defense argued that they were beating a dead horse, you know, showing this relationship.
Yeah, no. So to shortcut it all, I think the error isn't invited. Error is invited when the judge is asked to do something that then the defense complains about. Well, you asked the judge to do it, right? You asked the judge to do this by email. How do you complain now about the judge doing it by email? Sorry. So legal insufficiency is not error that could be invited. I suppose it could be invited by stipulating to the facts.
Isn't that in effect kind of what
It's
happened?
not.
Because you have
It's
a motion
not.
in limine, you're asking the judge not to allow this evidence in, and now you're complaining that they didn't put this evidence on.
It's good lawyering. It's good lawyering, Your Honor.
I don't want evidence of guilt coming into this trial.
It's prejudicial. It's the essence of prejudice. I don't know what was going through trial counsel's mind, Judge Parker, but it's conceivable to me that the trial counsel thought the state had something else that they didn't, that they could introduce. They should have. Really, the state should have had something else here. I think what happened, probably just from reading the cold record, is probably the state came into this trial thinking that they were going to get that bond hearing transcript into evidence. Now, the bond hearing transcript was not admissible, no matter what the defense or the state said at the motion in limine hearing. It wasn't. It shouldn't. The questions shouldn't even have been permitted at the bond hearing. Once the questions were asked, they shouldn't have been admitted. But the fact that the defense argues, well, you know, this shouldn't come in, doesn't excuse the state from proving the case beyond a reasonable doubt. The state proves cases beyond a reasonable doubt with belts and suspenders and staples, right? You should try 3 different ways. You should have, even if you're the defense, you should have 3 different ways to keep everything out. If you're the state, you should have 3 different ways to prove every element of your case. They didn't have one. I think they thought they had one, and I think the motion in limine might have been a surprise to them when that was excluded, but it was properly excluded. And once the motion in limine was granted, they didn't try to introduce the evidence. And so if they were the defense, they wouldn't be able to complain about that, because the motion in limine doesn't preserve anything for appeal. They didn't try to cross-appeal. If they had preserved that for appeal, then they could have cross-appealed, but they didn't even preserve it for appeal because it was just a motion in limine, and that doesn't preserve anything. So the state, if they had wanted to advance this theory that we had invited the error, they should have offered the testimony into evidence at trial. Approach the bench, say, Judge, we'd like to get into this now. Then the judge says, nope, not going to let you get into it. Then they've preserved something for appeal. The rules should be the same for the defense and for the state. And that would be the rule if it were evidence that I were trying to object to. You'd be saying to me, Mr. Bennett, did you, after the motion in limine, did you offer the evidence? No, I didn't. Okay, well, how's it preserved? It's not preserved.
Thank you. You've reserved 5 minutes for rebuttal. Thank you for giving
All
us.
right, thank you very
You've
much.
given us a minute back.
All right.
Appreciate it. We will now hear from Ms. Weatherford for the state.
May it please the court, counsel. My name is Holly Weatherford, and I represent the state of Texas. I'm here on behalf of the Comal County Criminal District Attorney's Office. This is my first time arguing before the court, so thank you very much for this opportunity. This court, as we were mentioning, in the similar context of proving up a prior conviction, has stated that reviewing the sufficiency of the evidence is much like putting together a jigsaw puzzle. And so standing alone, those pieces may not, or may have little meaning, but together, of course, they put together the picture. And so the question today for this court is whether the state's puzzle pieces, or the evidence that they introduced at trial, form the picture that appellant's previous conviction involved family violence. And the jury's verdict, the holding of the Third Court of Appeals, and the state's position, of course, is that they did. And so I'd like to go through exactly what those puzzle pieces were, what the state introduced at trial. We've talked about it a little bit, but we had the certified judgment that showed, of course, Roberto Garcia was convicted of aggravated assault with a deadly weapon, and that's not contested, of course. We know that that conviction belonged to him through fingerprints that were matched at trial.
That Exhibit 27, the fingerprint card, that's from the original judgment?
Sorry, 27 would be from the previous conviction.
And it was a fingerprint expert who matched the two Garcias, correct?
Yes, Your Honor. So he took his own fingerprints in Exhibit 26. Exhibit 27 were the fingerprints from that prior conviction, and he did match those to him. And so that, the information was, I'm sorry, am I too loud here? Okay, I sound very loud.
You cannot be too loud, you cannot be too clear.
Oh, okay. The next thing that they introduced was the information, and that was positively tied to the certified judgment. It had the same cause number. The information listed Roberto Garcia as having assaulted Olivia Garcia by cutting her with a knife on May 20th, 2004 in Bexar County. The next thing we had was the marriage license, and the marriage license had Roberto Garcia marrying Olivia Lopez, and that was on May 14th of 2004 in Bexar County. So that's only, as you mentioned, 6 days prior to the aggravated assault, to the date of offense of the aggravated assault. The next piece of evidence, of course, is Ronnie Womack's testimony. He was the state's fingerprint expert, and he testified that the two people listed in the marriage license that was introduced into evidence were the same two people that were in the information.
Was there any objection to that testimony?
There was no objection, Your Honor.
Does the record show what the basis for that conclusion by him was?
No, he does not state he was not asked what the basis for his conclusion was, to answer your question directly. However, I think it's incredibly important that the appellant did not object to that testimony, because had he objected, the state may have asked what his basis was, but...
Well, he doesn't have to participate at the trial at all, does he?
I'm sorry?
He doesn't have to participate at trial at all, right? It's your job
Correct, Your
to
Honor.
produce sufficient proof, right? So if you got a statement from somebody that says
Yes.
guilty, what evidentiary weight does that have?
Well, once the state had that testimony from Ronnie Womack, they had what they needed to prove.
Well, that depends on the weight that can be given to the conclusory statement that it is, without any basis for it's an opinion, right?
Well, he has, the state introduced each of these pieces of evidence to this particular witness. And so he's reviewed each of those that I just mentioned in front of the jury.
And he's an expert on documents, is that, I mean, how does that help the jury get to where it needs to go on she's the same person? I'm with you on, I got the fingerprints, you've got half of it cooking. It's the other half and getting through the morass of our ancient case law on prove the people are the people that seems to me we got to walk through here. You've got potentially an inference, I guess, that who would he be stabbing with 6 days after he's married, if not the woman he got married to? That would be infidelity to be attacking some other person. Why couldn't a juror, if you're going to abuse somebody, it'd be your own spouse within 6 days of getting married, right?
Well, Your Honor, I think that the jury is the exclusive judge of the evidence in this case, and they had that testimony before them, so they were entitled to believe that Womack's testimony, that the two people that are in the marriage license were the same two people that were in the judgment or the information.
Did defense counsel cross-examine the fingerprint expert as to how he knew that the two women were the same?
There was no objection, Your Honor, and no
I
cross-examination.
mean, during cross-examination, was there a cross-examination? And if there was, did defense counsel explore how this testifying expert, who had testified that these two were the same women, how he knew that?
No, Your Honor.
Okay.
Is it often that defense attorneys try to help the state make the case against them? No.
You're doing great. So how do we get, how do we get the wife as the victim? Okay, we've got the marriage license. We got the fact of the assault occurring very proximate to the fact of the wedding, and you've got an expert in fingerprint matching that's got the defendant. Where else can we get, other than the conclusory statement of somebody that these are the same people? And maybe that's enough, but is there anything else beyond what we just went through to identify the victim as the same person between these two?
This is the evidence that we're working with, Your Honor. We've got the certified judgment, the information, the marriage license, Ronnie Womack's testimony, and certainly the 6 days between the marriage and the assault. It was in the same county, so marriage license, they get married in Bexar County. The assault occurs in Bexar County. It's arguably the same type of offense. The offense in the instant case was an assault family violence. This is an assault against a woman. The corresponding names, of course, the marriage license has her maiden name, but as the Third Court of Appeals found, it was a rational inference for the jury to make the rational inference that she changed her name after she got married to Roberto Garcia.
O-G and O-L, right? And there's only 26 letters in the English alphabet, right? So it'd be quite a coincidence for those to match up, right?
For the O-G and O-L, yes. And this wasn't Olivia Lopez going to Olivia Martinez. We've got Olivia Lopez going to Olivia Garcia, which matches the surname of the appellant in the information and judgment. And finally, Womack's testimony that they were the same people. I think appellant takes pains in his brief to say that this court, shouldn't consider his testimony, but I think if you actually go to his testimony, it's relatively short. It's about 14 pages long. He goes through, like I said, each piece of evidence. The state goes through with him one by one, State's Exhibit 26, 27, 28, 29, finally 30, which it was the marriage license. After he positively identifies the defendant as being the person in the previous conviction, she comes back and puts up the one right before it, I believe it's State's Exhibit 29, and asks him, who are the two people in this information? Roberto Garcia and Olivia Garcia. And then she puts up State's Exhibit 30, which is the marriage license, and asks him, are these the two people that you mentioned earlier? Other than his own name, Ronnie Womack never testified about any other names. He only testified about Olivia Garcia and Roberto Garcia. And so when the state asks him, are these the same two people that you just testified about earlier? He responds yes, and it's the state's position that he's affirmatively saying that the people in the marriage license are the same two people that he was testifying about in the information.
It sort of feels like the snake is eating its tail here, because it sounds like what you're saying is Womack knows that these are the same people because he knows that these are the same people. Like, he doesn't really know these are the same people. I mean, he literally has no way of knowing these are the same people except names and the proximity between the marriage and the assault, right?
Well, Your Honor, if he would have been, if the testimony would have been objected to, we don't know what it was that he was
But
basing it. He very may well have known.
But does the evidence become more sufficient just because somebody objects? You're almost, kind of like what Judge Newell said in a way, it's more probative because the defense is upset. That sounds like what you're saying. I guess just address my concern that when, let's just say you grab just some random person in the hallway during the trial, threw them on the witness stand, and asked them, like they hadn't examined a single thing, are the people in the complaint from which he had his previous conviction the same people from the marriage license? And they said yes, and they knew nothing about anything, and nobody objected. Like, you're not saying we should just go, oh well, nobody objected and they said it, so that's good enough. help me get over my reluctance to go down that path, that just because somebody says something, but they don't really have a basis for saying it, we should just accept it anyway.
I think, again, we have to look at all of these exhibits together, and it's kind of like they're not self-proving, but they prove each other when you put them together. And so I think Ronnie Womack's testimony is really important, and I think the fact that it was not objected to is really important as well. But how absurd would the coincidences have to be for these to be two different people? But
Maybe he just likes women named Olivia.
likes to. We've got same county, within 6 days of marriage, same names on there.
So if you calculated the odds, you seem to be saying that it would be very unusual for these to be different people, or for at least the complaining witness to have been somebody else.
The odds, when you take into consideration, again, the county, the similar offenses, the names, the date, the proximity in time and circumstances.
So how do you articulate that in terms of the standard of review for sufficiency of the evidence? What is the standard, and how does this evidence match up to that?
As far as the standard of review for sufficiency of the evidence would be, this court reviews the combined and cumulative force of the evidence in this case in the light most favorable to the jury's verdict. And so I think all of the pieces of evidence, and sure, could the evidence have been more? Yes, of course. But we have what we're working with, and when you look at those in the light most favorable to the verdict, it's the state's position that it's sufficient. It's sufficient to show that the previous conviction.
Is it a rational inference for the jury to make?
Yes,
Based
Your
on the
Honor.
evidence presented, when we view the verdict in the light, we view the evidence sufficiency in the light most favorable to the verdict, is it a rational inference for the jury to make that these are the same two women?
It is a rational inference,
I
yes.
think Judge Keel's question is, why is it a rational inference?
Why is it a rational inference? Well, as the third court said in their opinion, it was a rational inference for the jury to believe that Olivia Lopez had changed her name to Garcia. And so when you have the evidence that shows that, again, the marriage license, Olivia Lopez goes to Olivia Garcia, we have Olivia Garcia in the judgment, there's a rational inference to be made there that it's the same person, based on all these things that I've been talking about, the county and the proximity and time.
Counsel, you've mentioned before several times that there was no objection. Haven't we been offered the opportunity to sort of take care of these kinds of things as an evidentiary issue for the admissibility of, say, an unfounded opinion? Haven't we already been offered that opportunity and chose not to go down that path?
In terms of what? I'm sorry.
There was a case we had where the offer or the suggestion is that we should be looking at these things as evidentiary issues with regard to the fact that someone gets up and they don't give their basis of knowledge means that the testimony would be admissible or not. But because no one's objected, that
Yes.
means that the evidence would come in, and then we just look at that evidence and say, well, we can now rely on it exactly as it is without considering whether or not it rises to the level of beyond a reasonable doubt. We had that, and we chose not to go down that path, right?
Well, I think.
It's hard for me to understand too. So just in case you're struggling with.
No, look, I can tell you the case called Baltimore versus State. This is an argument that we've had with regard to sufficiency and whether or not unfounded opinions about facts can be the basis from which a rational finding can be made. And the suggestion was, well, if somebody doesn't object, then it comes in for all purposes, and therefore we can still rely on it. And we were offered the opportunity to say, yeah, we're just going to treat that not as a sufficiency issue, but as an evidentiary issue. And we declined to do that. We treated it like a sufficiency issue. And we look at it and we determine whether or not the evidence supports it. So saying that this wasn't an objection, there was no objection, doesn't actually advance the ball for you. It doesn't give more quantum of evidence in your case, does it?
Well, I think counsel's or appellant's argument is still making it into an evidentiary, he's still couching his evidentiary claim as a sufficiency
Right.
issue. And I think that this court should review it as a sufficiency issue. And like you mentioned, the state's position is that Ronnie Womack's testimony came in before the jury, and it's our position that they should be allowed to consider it for all purposes, whether it was admissible or not, whether it was proper or not. And I think what appellant is really challenging is the competence or the probative value of his testimony. And so he's trying to say that it should be set aside, and I think that's still couching it as an evidentiary issue. So we can't first, or a reviewing court can't first say, well, let's see if this was admissible or not, or let's see if this was proper or not, and if that's in your favor, then we're not going to consider that in our sufficiency review. I think the proper thing to do is to allow Ronnie Womack's testimony to be considered with all of the evidence that was admitted here.
For whatever weight.
I'm sorry?
For whatever weight it had, right?
Well, again, I believe the jury is the one that is the exclusive judge of the weight of the evidence.
Let's change this case to, it's a bank robbery now, and the state calls one witness as a police officer. They don't say, are you the police officer who was at the bank? They don't say, did you see the suspect? They just ask, who robbed the bank? He says, the defendant. State rests. Sufficient evidence? Standing alone. But of course, your argument is not standing alone on the testimony of Officer Womack, right? Yeah.
Correct.
So we don't know what Officer Womack did. Officer Womack could very well have looked at the documents, looked up both of those women in the thing, cross-referenced them by social security number or date of birth. We don't know what he did or didn't do. There's an assumption seems here that he didn't have any information, but we don't know because it wasn't explored. He may very well have researched it as an officer on the case, correct?
Correct.
We just don't know because it wasn't explored what the basis for his testimony was. He may very well have had absolute concrete information to establish that those two women were the same. We just don't know the extent of his investigation because he wasn't asked.
That's correct, Your Honor. If there aren't any other questions, may I say something briefly?
Please do.
All right.
Tell us what you think we should do with this.
As we were talking about the standard for the sufficiency of the evidence, and when reviewing the combined and cumulative force of the evidence in this case and the reasonable inferences from that evidence, in the light most favorable to the jury's verdict, it's the state's position that it cannot be said that no rational jury could have concluded beyond a reasonable doubt that appellant's prior conviction for aggravated assault with a deadly weapon involved family violence. Because of that, we'd ask that you affirm the third court in this case, which is also the jury's verdict in this case. Thank you.
Thank you very much. An excellent job. We'll hear now from another excellent lawyer. You have 5 minutes.
Thank you. Welcome, Ms. Weatherford.
No, I've got a question for you. I'm sorry, you wanted to?
No, please.
Well, I wonder about this question that seems to have come up here, which is that, for example, sometimes an opinion might not be rational for the jury to rely upon that opinion. And here's my question is, at what point does it become like, because I think if indeed the people were not the people who this Ronnie witness said they were, at what point does it become the duty of the defense to start cross-examining and exposing that fact, right? At some point, the opinion might be found to be rational, right? And I think at that point, the in order to not be convicted that day, right?
Right.
You might need to persuade the jury that there are fundamental flaws in the conclusion that's been drawn. But I don't know whether the rules of evidence, what they say about what makes an opinion one that a jury can rely upon or not. Usually we say weight and credibility are for the jury.
I don't know either.
Okay.
If only there were a court to decide this. So
I'm waiting for the ball.
I have to correct something that Ms. Weatherford said. And words are important in this case. The exact words that are used are really terribly important because that's what the jury heard and that's what they could have or could not have concluded things from. And Ms. Weatherford, in order to make her case, said something to the effect of, Womack was asked, are these the two people you just talked about? And Womack said, yes. That's wrong. That's wrong. It wasn't, are these the two people you just talked about? It's, are these the two people you identified earlier? Earlier takes it back to some prior point in the testimony. And the only two people who he talked about, who he identified together, are the people in the marriage license. He said it's Roberto Garcia and it's Olivia Lopez, and then they circle back around. Are those the two people you identified earlier? Yeah, it's Roberto Garcia and Olivia Lopez. The state had this in their hands. If the officer had known the thing, they could have asked the question and they would have gotten an answer. Either I don't know, and I think I don't know is probably here, Judge Erie, because when you look earlier in the transcript, he's asked the first time about Exhibit 30, can you tell the jury what that is? It shows to be a marriage license. And Judge Finley, if he had done this research and this investigation, he wouldn't say it shows to be a marriage license. Clearly, this is his first time looking at the document. He'd say that's a marriage license.
Right, but the flip side of that coin is, if defense counsel had cross-examined him and undermined the foundation for his opinion, the state then would have been on notice that they had to put additional evidence in to establish the link between these two people.
Absolutely.
But defense counsel didn't do that, so why is the state not then entitled to say, hey, we got evidence in this, and we got testimony that says these are the same two people, there we go.
Because it's not evidence, it's not testimony that says they're the same two people, Judge Finley. There's no way to look at it to say, oh, he is saying that these are the same two people. He's saying this document looks like this thing. It's got these two names on it. 4 pages later, are these the two people that you identified? Yes.
Even leaving aside his testimony, how is it when the jury looks at the marriage license, the name, and the assault that occurred 6 days after the marriage in the same city, in the same state, how is that not a rational inference from the evidence that they're the same two people?
Because Bexar County is a big place with lots of Garcias. And the state picks out 2 pieces of...
And Lopez, and Lopez.
Sorry?
And Lopez.
Are we taking judicial notice of that?
Counsel, counsel, is the defense under any obligation to give the state notice when it's not proving its case?
No, and that's what legal insufficiency is about. We wouldn't have legal insufficiency cases if every time the state the defense had to object to or make a record of how the evidence is legally insufficient. If the state is clearly making a legally insufficient case, we sit back, we shouldn't do anything.
If the state introduces clear hearsay, which establishes a critical element of their case, and the defendant objects, then the state's got to establish that element through something else. But if the state doesn't object, you cannot then come back to be heard to say, well, that's insufficient evidence because the document upon which that element was proved was hearsay.
We're not
Here you're talking the foundation of an opinion.
But we're not talking about hearsay. First of all, hearsay is a procedural rule, and the rule against hearsay allows us to encounter and to cross-examine the person who said it. We're talking about somebody who doesn't know the answer to the question.
May not know.
I think clear, okay.
Wait.
From this record, appears not to know the answer to the question. Appears strongly enough not to know the answer to the question, yes.
What if Womack had been cross-examined and they said, hey, what's the basis for your testimony here? And they tore him up on cross-examination. But he stuck to his gun, stuck to his testimony. Those are the same two people. Wouldn't you still be asking us just to reweigh the evidence? And isn't that really what you're asking us to do now?
No, I wouldn't, because here, the difference that I think the state and I have is that the state thinks that Womack testified that these are the same two people as in the complaint. And I read the transcript, and that's not what Womack testified to. Now, if he had said, these are the same two people in the complaint, I think we'd have a problem. I think that despite the fact that there's no basis for that, I think the court could look at it and say, well, we might not know what his basis for it is, but we have the combination of things here where first he says, I don't know what the document is, or it appears to be, and then he says, not these are the same two people as in the complaint, but these are the same two people I identified earlier before something else happened at an indeterminate point.
But if you look at it in the light most favorable to the verdict.
I think that a rational juror could not conclude from that testimony that the people in the marriage license were the same as the people in the complaint. And I know I'm out of time. May I give you an analogy?
Quickly, yes.
Suppose that somebody testifies, that he's asked the question, are these the same two people as in the complaint, in the marriage license? And he says, I have no idea, but yes. Right? Do you then parse it so finely that you say the jury could disregard his saying he has no idea and take as the truth his yes? I don't believe that we do that. For those reasons, we ask that the court reverse the judgment of the Third Court of Appeals and render a judgment of acquittal for reasons in my briefing.
Thank you both very much for a very fine argument. We hope we'll see you again. We'll take this case under submission.